I'm Nick Brooks, a California litigation attorney, and today we're asking whether Turning Point USA could actually win a defamation lawsuit against Wolves and Finance. TPUSA, a big political nonprofit, just sent a 4-page demand over YouTube videos. We'll walk through defamation and Arizona's anti-SLAPP statute, then pressure test this case. Zach De Gregorio runs Wolves and Finance, a channel where a working accountant pulls public filings and explains how money appears to move inside powerful organizations. He's built quite an audience by turning dry Form 990s into understandable, dramatic financial stories. Before YouTube, Zach was CFO of the New Mexico Spaceport Authority. In 2022, he filed a whistleblower lawsuit alleging serious financial misconduct by state officials over Spaceport America funding, and he says his complaints helped trigger investigations and leadership changes. Supporters of Zach point to that history as evidence that he can read complex government numbers and is willing to challenge powerful institutions. Turning Point, if it litigates, is likely to say it shows he gravitates toward big fraud narratives and prefers being at the center of high-stakes allegations against large entities because that's become part of his persona. So, on January 8th, Turning Point's lawyers sent Zach a 4-page demand to cease and desist defamatory comments letter, basically the classic first step toward a defamation lawsuit. It cites Arizona cases, calls many of his statements demonstrably false, and says they've caused serious reputational harm and even threats to Turning Point staff. The letter points to Zach's videos after Charlie Kirk's assassination, saying he used titles like "Did Turning Point USA commit fraud?" and "More fraud at Turning Point USA." Also talked about ghost employees, questioned a $650,000 transfer, referenced shell entities, and raised bribe questions. The letter somewhat reads like a lawsuit in draft form. It identifies specific statements, asserts reputational injury, and includes a broad evidence preservation demand. Legally, it does not just complain about old videos. It's designed to put Zach on clear notice so any similar future statements look reckless if Turning Point later has to prove actual malice in court. Zach, in turn, wants this to look like David versus Goliath, a small YouTube accountant reading public records versus a well-funded political nonprofit with lawyers and donors. That underdog framing helps his audience see any lawsuit as a way to silence a critic rather than to fix falsehoods. In his recent response video, Zach reads the letter on air, walks through Turning Point's complaints, mocks parts of their wording, and says he's glad to correct any factual errors. At the same time, he signals he'll keep covering them, ask viewers to help him find an Arizona defamation lawyer, and even ask his audience to help fund potential legal fees if this turns into a lawsuit. In court, Turning Point must show Zach made provably false statements of fact, that he published them, and that they harmed its reputation. Because TPUSA includes public figure players, they must also prove actual malice, that Zach either knew what he was saying to be false or seriously doubted it was true at the time he said it. The core fight is over facts versus opinions. Turning Point will highlight firm-sounding lines such as "more fraud," bribes, ghost employees, as false factual accusations. Zach, on the other hand, will say he showed the 990s on screen, added caveats about no proof of crime, and was giving interpretations, not insider facts. Courts care about tone. Insults like "clowns of the year" or calling their structure a shell game sounds like rhetorical hyperbole or colorful opinion. Statements that sound like "Turning Point did commit fraud" or "this payment was a bribe" look more like concrete factual claims a jury can test. Turning Point will focus on how words like fraud, bribe, and ghost employees land with normal viewers. Those terms usually suggest criminal-level misconduct, not just sloppy management. So they'll argue Zach's language tells people, in substance, these folks are doing crimes. TPUSA's best lane is to narrow the case to a few concrete statements, such as the "more fraud" framing, any unqualified claims that money was a bribe, and firm statements that Turning Point had ghost employees. They'll match those against their explanations about 990 errors, reimbursement, and a legitimate marketing vendor. Some clashes here are mostly spin, like calling multiple related nonprofits a shell game when money really is moving between disclosed Turning Point entities. But other wording is not trivial. Changing a Doge effort into a Doge audit matters because audit suggests outside investigation in a way effort does not. Zach's defense will be that he's a watchdog commentator. He'll say he relies on public records, shows documents on screen, quotes Turning Point's own letter, corrects when new forms appear, and repeatedly tells viewers he has no evidence of a crime but sees financial red flags. In his recent video, Zach keeps repeating, "I do not understand this letter," and "I don't understand what Erica is doing." But this is a former government CFO who walks through complex tax filings and headcounts in detail. It's hard to believe he truly does not understand. "I don't understand" works as a performance that lets him say, "This is so bad it makes no sense," while softening how aggressive his accusations sound. Ultimately, Arizona's anti-SLAPP law lets defendants attack lawsuits aimed at speech about public issues. In simple terms, you can tell the judge early, "This case is really about shutting me up," and if the judge agrees, the suit can be tossed quickly and the plaintiff may have to pay your fees. If Turning Point files in Arizona, Zach can argue his videos are commentary on political nonprofits' finances, a classic public concern topic. A judge who sees the case as punishing criticism instead of fixing clear lies could kill it at the anti-SLAPP stage and order Turning Point to pay his lawyers. It must be noted from a litigator's perspective, Zach is building their trial exhibits for them. Once you've been put on notice, every new video, every "they're threatening to sue me" riff, every fundraising pitch becomes a party admission and potential actual malice evidence. This is why lawyers tell clients not to keep doing commentary about their own potential lawsuit unless they're comfortable watching those clips played back to a jury. Overall, Turning Point has a narrow path. Focus on a few concrete statements, such as more fraud, bribes, ghost employees, and argue Zach ignored their explanations after notice. With public figure rules and Arizona's anti-SLAPP protection, the odds still tilt slightly towards Zach, either cutting off a broad suit early or, if a narrower claim gets past the first motions, having enough First Amendment and opinion defenses to make litigation risky and expensive for Turning Point, especially if he tightens his wording with counsel going forward. If you found this video helpful, please hit like so more people see it. Before you go, tell me in the comments whether a Turning Point lawsuit here would be legitimate reputational protection or political warfare against a critic. If someone you know follows Turning Point or works in nonprofit compliance, send this video to them so they can see where the legal line really is. And if you want more breakdowns like this from a California attorney, subscribe and turn on notifications so that you don't miss the next episode. Thank you very much.